Looks like we have the board here and the applicant is here. Representatives of the applicant. Welcome, everybody. Let me just a second here. So let me first say that, hold on, I gotta make sure closed captioning is on. I think it's on. Okay, so this is a meeting of the Dover Zoning Board of Appeals. The meeting is being recorded. We are resuming the hearing on an application by Robert Recchia for the issuance of a comprehensive permit under General Laws, Chapter 40B, Sections 20 to 23, for parcels on Trout Brook Road, Chickering Drive, and Edgewater Drive in Dover. So last time we met, we raised and discussed the issue of this being a scattered site project, whether the 2001 decision in Farm Street Trust versus Dover Board of Appeals had any application to the current application. For those who haven't been attending our previous meetings, in the Farm Street Trust case, which happened to be in Dover, the applicant wanted to build on two non-contiguous lots with an affordable unit on one lot, but a market rate unit on the other. The board denied the permit because the lots were otherwise not buildable, and the Housing Appeals Committee on appeal upheld that decision. And that's a similar situation to what we have here. Attorney Silverstein for the applicant submitted a letter addressing the issue of whether that case should apply to the current situation. And we thank you for that. The argument, as I understand it, was that after that 2001 decision, Mass Housing revised its regulations in 2008. They were comprehensively amended and recodified. The suggestion was that that was likely in response to the Farm Street Trust decision, the 2001 Dover decision, and that under the revised regs, the PEL letter from Mass Housing determined that the PEL is project eligibility letter. And in the PEL letter, the agency determined that the project eligibility requirements have been met. Those requirements are that the applicant is an appropriate entity for a 40B permit, that the project is fundable by a subsidizing agency, and that the applicant controls the site. And Attorney Silverstein went on to argue that in making that determination, the regs require that the agency in its PEL letter make certain findings under the regulations, including findings that the site is generally appropriate for residential development and that the conceptual project design is generally appropriate for the site. And it does, at some one point, make reference to the fact that the proposal here involves scattered sites, and therefore the argument is that the PEL constitutes a determination that a scattered site project on lots that are otherwise not buildable is acceptable, and therefore a 40B permit cannot be denied on that basis. Jonathan, does that sound like a fair description of your letter to the board?
It does, Mr. Chair. Thank you.
So we have received a letter from an attorney for some of the people who live in the neighborhood where the Trout Brook project is being proposed. The attorney's name is, I believe, Dennis Murphy. Mr. Murphy, are you with us?
Yes, good evening, Mr. Chair.
You submitted a letter taking issue with Attorney Silverstein's analysis. What I'd like to do at this point is give you an opportunity to present your point of view on behalf of the residents of the neighborhood.
Well, thank you for that. And just by way of introduction, my name is Dennis Murphy. I practice in this area quite a bit, although I think this might be my first appearance before the Dover Zoning Board, so it's nice to meet you. I served on my own town zoning board for nearly a decade and heard a number of 40Bs. And the one thing I want to just be clear is when I submitted the letter yesterday, I included most of the names, but I have since learned that there are 8 additional neighbors that have signed on. And so I will submit an updated letter with everyone's name and address. The problem from 22 years ago was that, as the chairman just said, there was 2 non-contiguous lots, one of which would be just market rate housing, and the other of which would be affordable. The situation today is much the same, although doubly so. This situation involves 4 scattered sites and only 1 affordable, but the same issues are confronted. And I don't want to repeat what I have in my letter. I just have really 3 quick points to summarize. The first is that the way 40B works is it allows a zoning board to waive local zoning. The requirement that 25% of the units be affordable is not a Dover zoning requirement. That is the state law. And so part of me thinks that when I sat in your shoes, it's always a question of who decides this issue. Am I really the right person to have to make this decision? In the first instance, that was the case 20 odd years ago, and it was affirmed. But I question whether the zoning board has the power to waive the state law requirement that 1/4 of the units be affordable. So that's my first point. That's not actually in my letter. The second point I wanted to make is that on the question of who decides, I can tell you who it's not. It's not Mass Housing. Mass Housing is a gatekeeper, and they issued a letter that was based on information provided to them. And if nothing else, I would say that this issue merits some consideration, and there is none whatsoever. There's no evaluation in Mass Housing's letter about whether the Farm Street Trust case remains viable, was a good decision, it is still binding after 22 years. It says nothing about it. So if someone's going to overrule something, it shouldn't be silently. It should be done with some analysis about why the law has changed or the rules have changed. The last point I want to make that wasn't quite articulated in my letter is that one thing that is clear is these 4 sites were sold at below market rate. The deed says it was $12,000 for 4 lots in Dover 19 years ago in 2004. And it was Harvard that sold the lots. I don't know the circumstances of that sale, but it doesn't seem to be the grantor's intention that these be developed and that people profit from them. And one of the things that is in the HAC decision from 22 years ago, in a footnote, footnote 2, is it says, look, if you want to do affordable housing, the developer is free to put affordable housing on every lot. And that I think would be acceptable. And it would also be consistent with what seems to be the purpose behind the sale for $3,000 a lot. Even though it was 20 years ago, that's still very cheap land in Dover. So my bottom line recommendation is that it's an issue that's already been decided. I don't think the board has to revisit it. If it does revisit it, I've given several reasons why you should come out the same way. And your decision was affirmed by the state agency, HAC. If you do come out the same way, and HAC has a principled way of distinguishing this situation or of explaining why the facts or circumstances have changed, I'm sure they'll tell you politely, and you'll get another crack at this. So my bottom line recommendation is that rather than take the next 6 months to hear the merits of the project, if there is a consensus on the board that for the same reasons it denied the Farm Street Trust project 20 odd years ago, if that's the consensus of the board this time, then it ought to be voted without delay. Thank you very much.
So thank you for that. I wanted to ask you a few questions.
Of course.
Are you aware of any decision that has either overruled or questioned the decision by the HAC in that 2001 case?
No, Mr. Chair, I did look this up. I did both a docket search in the land court and the Superior Court, as well as on Westlaw and Lexis, and I looked for Farm Street Trust as well as Dover Zoning Board, and I could find no evidence that this case was ever appealed.
Another question: are there, under the revised regulations, is there anywhere in those regulations that it addresses or discusses in any way the issue of unbuildable scattered sites for a 40B project?
No, thanks to OCR technology, you can do term searches, and I did look for the word scattered. It does not appear in 760 CMR 56, which is the 2008 regulation.
Okay, next question. The provision we're dealing with here for the PEL letter is 760 CMR 56.04(1). Do you know to what extent the language in that section has changed from the previous version of the regulations?
That's a good question. I did not do a side-by-side comparison. Before this was codified at section 56, it was section 31, I believe. I think there were changes to the project eligibility regulations, which is the one you reference. But there was nothing specific about non-contiguous or scattered sites, at least nothing that I found.
Okay. So the findings that are made under 56.04(4) are to establish eligibility under 56.04(1), correct?
Yes, that's right.
Is there anything in the regs that suggests that those findings limit the board's ability to address any issues other than project eligibility?
No, in fact, I think you said it accurately, which is that the subsidizing agency has exclusive jurisdiction over the project eligibility determination, and they could revisit it. You could ask them to, but project eligibility determinations wouldn't normally involve a review of case law from 20 years ago, and they certainly wouldn't delve into a legal issue like whether a scattered site 40B was appropriate under the law.
So is there anything in the regulations that you're aware of that would suggest that the findings made in the PEL to determine project eligibility in any way limit the board's ability to evaluate this issue of scattered site development on otherwise unbuildable lots?
No, I don't think it limits your ability to evaluate. There's two reasons. One is you accurately said what the project eligibility is factual determinations about the nature of the site. And let me give you a quick example. There have been 1,150 odd project eligibilities based on Mass Housing's own number. I can count on one, maybe two hands, the number of times it's been denied. One of those involved a commercial project, and it had ancillary residential, and it was denied at the project eligibility stage because 40B is intended to facilitate residential development. So there's an example where Mass Housing fulfilled its gatekeeping function by saying this wasn't meant to facilitate commercial development with an apartment upstairs in each of the stores. And the second point I wanted to make, so Mass Housing is making a factual determination. They'll come and look at the site. They'll see whether it can support residential development. They'll do a cursory evaluation of the design to make sure it's appropriate. And most importantly, they make a preliminary financial analysis to make sure that the project is fundable and makes sense money-wise.
Okay. Anything else you want to say at this point in terms of representing your clients in the neighborhood?
No, I appreciate that the board has taken such a keen look at this issue. I said this in my letter. It's not very often that you have a question that's been definitively answered. This is one that I think it has, and it's just a question of whether the board is interested in revisiting it.
Okay, thank you. So at this point, what I want to do is turn to Attorney Silverstein and give him an opportunity to address the issues that you've just addressed. Jonathan?
I think what everyone seems to be ignoring here is that the HAC decision from more than 20 years ago stated very clearly that it was upholding, it was deferring to the determination of the local board because there had been no determination by the subsidizing authority on a matter of policy. Mr. Murphy, I wouldn't feel comfortable representing a 40B applicant if I didn't see Dennis on the other side opposing the project. By the way, the last scattered site development that I represented the developer was in Duxbury, and Mr. Murphy represented those neighbors as well in opposing the project. That project was approved and is now continuing on with the permitting, another scattered site development. And the ZBA, as I think I mentioned in a previous meeting, was chaired by Judy Barrett, who is your 40B consultant in this matter. So the HAC stated very clearly that because there had been no determination that the scattered site project was appropriate, that HAC would defer to the ZBA. So to answer one of your questions, Mr. Chair, the regulations were changed in 2008 to specifically require specific findings by the subsidizing authority in support of fundability. And one of, you can't look at them in a vacuum. Fundability requires a number of determinations, including eligibility. Eligibility specifically requires that the subsidizing authority find that the site is appropriate. So here, and Mr. Murphy can say that, you know, eligibility letters aren't often denied. That's true. That's a policy. There's a policy reason for that. And it's exactly the sort of policy determination that the HAC said should be made by the subsidizing authority. And I'll get to that in a moment, that policy. But the subsidizing authority is now required, was not under the old NEF program, but is now required to make a specific finding about the appropriateness of the site. It did so. That was a prerequisite to finding that the project is eligible for funding. You can't separate those two. One is a predicate of the other. And the regulations also now say, did not say in 2001, that those determinations shall be treated as conclusive by the board. So, unlike when Farm Street was decided, there are now specific regulatory requirements that the subsidizing agency find the site to be appropriate, and further that the board is required to defer to those findings, and that it's conclusive unless the board asks HAC to determine that changes in circumstance have arisen that would call those determinations into question. What has also changed in the last 20 years is that the HAC determination that as a matter of policy, it was reasonable for the Dover Board of Appeals to deny a scattered site project. I think, even absent the changes in the regulations, would not be the determination today, because in 20 years, Dover has done next to nothing to help address the affordable housing crisis, which has exponentially intensified over the past 2 decades. And yet Dover is still at a 2.7%, I think, affordability, which is a paltry number. And to suggest that there's no benefit for to the affordable housing crisis to create a 4-bedroom single-family home on a lot of over 1 acre. Only in Dover would a lot of over 1 acre be unbuildable. The Chapter 40B is called the Anti-Snob Zoning Act. Very few communities have 2-acre zoning requirements. The notion that the board would even want to deny the opportunity of a family to move into such a house, even if it had the legal authority to do so, without first determining that whether there are legitimate environmental or other legitimate local concerns about impacts, simply because the lots are only 1 acre in size, it is frankly confusing. But the fact is that there has been no case, You asked, Mr. Chair, a very leading question of Mr. Murphy. Has there been any case that has overturned Farm Street? No. You know what there also has not been? A single case that has relied on it, cited it with approval, or upheld it. And given the change in attitudes at the state level towards affordable housing development, given the intensity of the crisis now compared to 20 years ago, I don't think you're going to see a decision to deny this project upheld at the HAC. Now, Mr. Murphy said, well, no problem. You can try, subtext, you can try to bleed the applicant dry by, Dover has plenty of money. Let's just litigate it and see if we can win a war of attrition. That's the specialty of 40B opponents. But don't count on the HAC sending this back to the board. This is the board's opportunity to give good faith, responsible consideration to a project that will create an unbelievable opportunity for a low-income family. I would certainly ask the HAC to simply make a determination regarding the issuance of a comprehensive permit. And Mr. Murphy will hopefully tell you that that is more frequently than not what the HAC will do when there have been denials that are overturned. So I don't know. I don't know why the board would want to do this, other than that certain people in certain communities don't want to see change and don't necessarily want to see the development of affordable housing. But I certainly think that the change to the regulations was very clearly designed to address a number of issues over it. Mr. Murphy sets up a straw man. I'm not saying that the entire recodification of the regulations was in response to Farm Street, but over the years, problems with the previous set of regulations were discovered, and there was a wholesale recodification that included the requirement that the subsidizing agency make specific findings. That decision to add that into the regulations did not take place in a vacuum, nor did the addition of the provision that says that local boards are required to treat those findings as conclusive. So I appreciate the time, and I'm happy to answer any questions that the board might have.
Well, thank you, Jonathan. I have to say I don't appreciate the tone of your comments. I get the distinct impression that you're suggesting that the board is hostile to this and looking for reasons to reject an application under 40B, and that's certainly not the case on my part. The last 40B we approved with certain conditions, and that's being built. I haven't been by there lately, but it's been progressing, and I think before too much longer, we'll be providing a lot of affordable units. So we're not out to try and kill any 40B application that gets submitted to us. We're looking at the legitimate legal issues that are involved. This deals with one of them. There may be others that come up if the hearing goes forward, but we're just doing our best to evaluate the issues that are there. And if the 2001 Dover decision is still good law, then we have to take that into account and apply that to the present circumstances to the extent that it's applicable. Right now, we haven't made any decision. Obviously, we're just exploring the scope of this issue and trying to figure out the extent to which it is an issue, and if so, how do we address it and resolve it?
Mr. Chairman, can I add a couple things on to what Jonathan said?
No, I'd like to finish what I'm saying first. I'll give you a chance in a moment.
Thank you.
I did want to ask you, Jonathan, I want to make sure I understand what you're saying. There's no question the regs say that the findings made in the PEL letter are conclusive with respect to the eligibility issue. But are you saying that they are conclusive as to the merits of any issues addressed as a result of those findings?
Mr. Chair, I'm saying that because the subsidizing agency is required to determine that the site is appropriate in order to make the finding that the project is fundable, that you can't separate those two.
So you're saying that they make that preliminary finding based on whatever you submitted to them, regardless of what may change or be further developed during the process, and that because they've made a finding that the site is, what's the language, generally appropriate for development and generally appropriate, the design is generally appropriate, that conclusively establishes that we cannot look at the substance of those issues as part of the hearing process?
Yeah, well, what I'm saying is that the determination that the project is fundable cannot be made under the regulations unless the subsidizing agency determines that the site is generally appropriate. Now, you reference change in circumstances. The regulations specifically allow the board to address and contest that determination based upon a change in circumstances. Does it bind the board with respect to the specifics of the project? No, it doesn't. But because the board has to hold evidentiary hearings with respect to the specifics of the project. But one thing that is not in question is what is the site, and is the site generally appropriate? The site is 4 scattered sites. That hasn't changed. That doesn't require any elucidation or factual development through the hearing process. It was clear at the project eligibility stage, and it's clear now. Now, the extent of wetlands on a site, or the amount of traffic generated by a project, or all these other things that are traditionally addressed through the public hearing process, those are clearly not binding, because that's not something that's fully developed and clear and has to be made as has to clearly have been part of the determination that the site is generally appropriate. But the subsidizing agency specifically acknowledged that this is a scattered site project and went on to find that the site is generally appropriate. So there's no change in circumstance there. There's no need for the board to consider local concerns or specific details of the project that are going to be elucidated during the public hearing process. Those are just clear facts that haven't changed, were clearly before the subsidizing authority when it made its determination under the regulations that the site is generally appropriate, which was one of the elements upon which it had to make a finding in order to determine that the project is fundable.
Is there any mention in the PEL letter of the fact that these sites are otherwise unbuildable?
I would have to go back and check that, but I would argue it doesn't matter, because, well, first of all, I would say, and this isn't a waiver argument, it's a basic fairness argument. 6 months after the town was asked for comments for this issue to be raised for the first time is patently unfair. That could have been raised with the subsidizing agency, and the subsidizing agency would have addressed it in its PEL. But it wasn't raised, and so I don't know that that was addressed. But I would say
I mean,
this
I
again.
can speak, I mean, if I'm allowed to speak, I can at least answer that particular question because we
Well, I'd
had.
appreciate it if you let Jonathan finish.
Yeah, and then, you know, certainly I think it makes sense to let Lynn address that after, but the fact is that the many 40B projects are built, including the last project in Duxbury that I referenced, the scattered site project. It was unbuildable property under local zoning, had been deemed unbuildable by the town, and it was funded and it was approved as a 40B. The fact is that 40B is there specifically because a lot of communities have local requirements that are so onerous that only large, expensive single-family houses can be built. So saying that it's unbuildable because it's only an acre in size, where in most towns you could build 2 or 3 or 4 houses on that lot. The question before the local subsidizing authority is whether or not the site is appropriate for development. And it conclusively made that determination in the affirmative.
So what I'm trying to do, Jonathan, is to try and establish whether you think that we're not permitted to further examine this issue based on the PEL letter being issued. And the PEL letter itself says on the second page that we've made findings required pursuant to those provisions. It says it's important to note that comprehensive permit rules limit mass housing to these specific findings in order to determine project eligibility. And it says that when the application is made to the Board of Appeals, at that time, local boards, officials, and members of the public are provided the opportunity to further review the project to ensure compliance with applicable state and local standards and regulations. And it goes on to say that the following issues should be addressed in the application to the ZBA, and the applicant should be prepared to explore them more fully during the hearing process. And that includes the point that development of the site requires compliance with all state and federal environmental laws, regulations, and standards applicable to existing conditions and to the proposed use related to wetlands protection, building construction, stormwater management, wastewater collection and treatment, and hazardous waste safety. And I read that in the PEL itself, and it sounds to me like it's saying that the board has it's within the scope of its authority to examine these issues and determine project eligibility and whether a permit should issue. Am I reading that wrong?
I think so, Mr. Chair. I'm looking at it as well. I see reference to state and federal environmental requirements because 40B cannot result in waiver of state or federal environmental requirements. There's no state or federal environmental requirement that precludes this project. I then see specifically reference to wetlands protection, building construction, stormwater management, wastewater collection and treatment, hazardous waste safety. I don't see any reference to zoning, you know, to 2-acre zoning requirements or anything of the like. So I don't see anything in this letter that in any way suggests that the question of the general appropriateness of the site for development, simply by virtue of the fact that it's a scattered site development, is up for grabs for the board. So to answer your question,
The issue isn't just scattered site development, it's scattered site development involving lots that would otherwise not be buildable.
Under local zoning.
Yes.
Right. Because Dover has chosen to adopt zoning that is so restrictive that there's no, that sites of over an acre couldn't be built on.
The issue
precisely because of such
these,
zoning.
The issue is not that these lots are not buildable because they're not over an acre. The issue is that because so much of each lot is wetlands, that they can't meet the requirements to make, these are 1 acre lots, as I understand it. So they would be buildable, except for the fact that they have major wetlands issues that would make them unbuildable under normal standards.
In which case, the board is free to look at wetlands protection issues under your local bylaw in the context of reviewing the project. But simply saying that because the lots on which these houses are proposed to be built are not contiguous, that in and of itself allows the board to deny the project would be inconsistent with the regulations and the PEL. If you get peer review feedback that this development of this project would result in significant environmental harm, then of course you're allowed to take that into consideration in determining whether to approve the project or what conditions to impose on the project. But that's not what I'm hearing. What I'm hearing is that because it's a scattered site development, independent of the wetlands resources or other environmental issues on one or more of the lots, that the mere fact that it's a scattered site development allows the board to deny the project. And I think it's quite clear that that is not the case.
And I don't think you're fairly characterizing the question we're asking, which is whether the fact that they are scattered sites, but also unbuildable because of the wetland issues absent the 40B, whether that means that the board can properly deny a permit. Nobody said we will. We're just exploring this issue of whether we have the power to do it because of the circumstances. And the 2001 Dover case says that at least at that time it was permissible to do so. And the question is whether we can still do that today. That's the question.
Well, Mr. Chair, I think those questions are separate. I think you are certainly allowed to look at wetlands. You are certainly allowed to look at floodplain issues. What I would submit you are not allowed to do is to base your decision on the fact that this is a scattered site project. Look, you could have a contiguous site that isn't buildable for exactly the same reasons. You could have a single 4-acre parcel that under your local zoning requirements or wetland bylaw would not be buildable, but would be buildable under state law. And you'd still have to look at that project. The mere fact that this happens to be 4 non-contiguous lots instead of a subdivision of 4 lots from a contiguous parcel is beside the point. And under the regulations, I would argue it's quite clear that no, you may not consider the fact that it's a scattered site project in making your decision. Though you certainly may consider issues under your local wetland protection bylaw or your local zoning bylaw with respect to legitimate local concerns, as the HAC has defined those through its case law.
Okay, I think I understand what you're saying. Thank you for that. Lynn Sweet, you wanted to say something?
Yeah, thank you very much, Lynn Sweet, LDS Consulting Group. I wanted to just add a couple of things to what Jonathan was saying. I appreciate the time. I know it's a tough issue to wrap your arms around. There are definitely a number of scattered site 40Bs that have been permitted. There's another one in addition to the Duxbury one that was permitted in Barnstable. The other thing is that when the state put into effect its GLAM guidelines, its gross land area mass guidelines, which is a safe harbor under 40B, they specifically included in that the possibility for scattered sites. So the state has looked at it, maybe not in the actual comprehensive permit statute, but in other statutes and guidelines that they, have put forth. And with regard to the conversations that were had with Mass Housing during the project eligibility process, I can assure you that I had numerous conversations with the head of the department, Jessica Malcolm, and with Catherine Miller there, before we even contemplated doing this, as to whether or not they thought a scattered site project would be allowed and would under 40B and under the project eligibility process. So they definitely talked about it. They are definitely aware of it. And they thought that given the proximity of the sites to each other, and obviously the finding that the buildings were going to be very similar and indistinguishable from the outside, that indeed that this was something that they issued a project eligibility letter for. And the last thing that I will say is that under state wetlands, these sites do comply with state wetlands, and that's why when we do these projects, we ask for waivers of local bylaws. So I appreciate the time and consideration you're giving to this matter. We certainly would like to be able to have, the peer reviews commence and have this project looked at on its merits.
Okay, thank you. I see that Mr. Murphy would like to say something. Dennis?
Yes, thank you, Mr. Chair. Just a few responses, if I could, to Attorney Silverstein. First of all, 2-acre zoning is lawful. 3-acre zoning is actually lawful in Edgartown. I did that case. There's nothing unlawful inherently about having zoning requirements. Second, there are no scattered site 40Bs in Duxbury. The project I think Attorney Silverstein refers to is a contiguous lot that has a portion across the road, on the same road directly across. And that kind of raises the question, what if you had scattered sites that were not in the same town? Could I have one on Nantucket? How about North Adams? What's the limiting principle for having scattered sites under 40B? Could I put one in Rhode Island? The third point I wanted to make is that the HAC, when they dealt with this, and that was a reasoned decision as a result of litigation on this exact issue, they said that it is a policy decision to be addressed in the first instance by the local Board of Appeals. The idea that Mass Housing has conclusively decided this without ever having or giving a reasoned decision, nothing from Mass Housing cites the Farm Street Trust case and explains why that's no longer binding. It would be very hard to square the HAC saying it's your job, Dover Zoning Board, with the argument that, well, Mass Housing has already decided this and it's conclusive, even though they don't tell you why. That's the thing that I find very troubling about the applicant's argument. So I think that has to be resolved if you're going to adopt it. Thank you.
Jonathan, you want to say something further?
Yeah, thank you, Mr. Chair. Just very briefly. That is not at all what the HAC said in Farm Street. Let me read to you exactly what the HAC said in Farm Street. The HAC said that this issue raises, blends the factual circumstances in Dover with public policy in a way that ideally would be resolved by the state or federal housing program that is subsidizing the development. But the subsidy mechanism here, the New England Fund, has been so designed that neither the Federal Home Loan Bank of Boston nor the lending member bank will address this question of public policy. Therefore, under the principles articulated in a previous case, this is a programmatic policy decision to be addressed in the first instance by the local Board of Appeals. Mr. Murphy would have you ignore the entire analysis that goes up to, well, because the subsidizing agency and the regulations won't address this issue, we have to defer to the local board. That has changed. The subsidizing agency is now explicitly required by the regulations to make a determination about the appropriateness of the site. It has done so in full knowledge of the fact that it's a scattered site.
Okay, thank you. So one question that has occurred to me, I don't know what the board will do with respect to this issue, because obviously we haven't even discussed it among ourselves yet. But if the board were to decide that the permit should be denied on the ground of the holding in the 2001 Dover decision, there's two options. One is to deny the application now on that basis, which would give the applicant the opportunity to pursue an appeal. The other is to proceed with the hearing on the merits of the application, look at all the issues, all the other issues involved, spend the time and the money and whatever to go through that process. And then if the application is denied, the applicant has the opportunity to appeal. Lynn or Jonathan, do you have any views on your preferred way to proceed?
Obviously, Mr. Chair, if it's a foregone conclusion that the board is going to deny the project because it's a scattered site project, then I think it would be patently unfair to force the applicant to endure the expense and burden of going through a meaningless public hearing process. So I think it's a matter of whether the board has an open mind to approving the project if its peer reviewers advise it that the project can be developed without substantial harm to a local interest that outweighs the need for affordable housing.
Because I'm not as conversant with the regulations as you are, but it may be that if, at least absent some agreement to the contrary, if the board were to deny the application on this ground without going through the rest of the hearing process, and the applicant prevails on appeal, then the board may be precluded from further reviewing the project and might be obligated to issue a permit without any other conditions and so forth. Do you have any thoughts on that? Is that your understanding of how it works?
Well, it would be up to the HAC, and what the HAC would do would be, I think this would be a summary decision issue. And if the HAC agreed with the appeal, then it would have the choice either to remand it to the board for further proceedings or to hold an evidentiary hearing itself. And the board would have the ability to present evidence on the substantive issues and to make whatever arguments it wants to make for whatever outcome, whether it's denial or conditional approval, it wants to see happen. So I can't tell you how the HAC would handle this procedurally definitively. That would be up to the hearing officer. But those would be the two likely outcomes as I see it.
So given those possibilities, would the applicant be not knowing what the board's going to do, but assuming for purposes of discussion that the board denies the application on the ground of the 2001 Dover case, would the applicant be agreeable on the record to an appeal on that basis so as to avoid the expense and delay of the hearing process going forward, and agree that if the applicant prevails, that the matter would come back to either have the other issues reviewed by the HAC or come back to the board on remand for completion of the hearing process. And you don't have to answer that, you don't have to give me a definitive answer now, but at some point soon, it would be helpful to know whether the applicant would be willing. My question is, can we agree to a process that still gives the board the opportunity to review the merits of the application on all the other grounds and consider any appropriate conditions to impose if it's going to be approved, and not lose the right to do that by having an expedited process for review of this kind of threshold issue?
Obviously, Mr. Chair, that I can't agree to anything without consulting with my client, but I'll say this. If the board were inclined to deny this project simply based upon the Farm Street decision, because it's a scattered site project, without determining that there is some environmental harm or other legitimate negative impact of the project, that tells me that the board's goal is not to give this project a fair hearing, but is rather to find a way to deny it. Because that would tell me that if there's a way to deny it, that's the board's intent, rather than determining if there are actually impacts that merit the denial. And that, coupled with some of the procedures that have gotten us to the point where we are, would make me very reluctant to agree to something like that, because frankly, I think it would be indicative that the project isn't going to get a fair hearing if it comes back here.
Okay, Lynn, did you want to say something?
I think I feel like I lost my point. So Mr. Murphy made this argument about it being a scattered site. Well, you could do it in another town. Again, I was privy to the conversations that took place with Mass Housing. They were very careful to go out and look at the site and see how close together the sites were, and basically made the statement that if it was another side of town, if it was a different neighborhood, they would not have approved it. They approved it because it was in the same neighborhood. So I'm just trying to kind of keep the facts straight here, because I worked very hard on the Pell process with the state agency.
Okay. Okay. So what I'd like to, well, first of all, let me ask you this, Lynn. You had said at previous hearings that there was additional work that the applicant was doing before it would be ready to discuss some of the other substantive issues. Where do we stand in terms of the applicant's readiness to address the other issues?
Sure. So we very much took to heart the concerns that were raised at the very first hearing about the floodplain. As you may recall, plans are basically, we submitted basic plans to you. We have actually since undergone some additional survey work and are very close to having new plans to submit with regard to locating looking at the new stormwater management bylaw from the town, looking at the new FEMA guidelines. and just checking on our floodplain lines and our topography. So we need another week or so before we're ready to submit plans that could be reviewed by the peer reviewer. And depending on where things go with the rest of this hearing, that was our intention. We very much want to get it going, and we actually appreciate having the time to really thoroughly check everything out, so that once the peer review takes place, hopefully we have everything that's needed.
What I think is a minor issue, you indicated you wanted to discuss the invoice from Tetra Tech.
You know, at this point, I don't want to be splitting hairs. I think that we, you know, need to move forward. I think they were at a few meetings. I don't think we realized that they were going to attend subsequent meetings until we had given some additional information for them to review. I think that's a minor issue compared to the other issues we're discussing tonight. So
Okay.
we're just going to let it go for now, but thank you.
Okay, that's fine. So an issue we were going to address and haven't yet is the, and what I'll do in a minute, I just want to get through these and get things out on the table, and then we'll get some input from the members of the board. The issue that we were going to address and then got delayed was whether the board should be engaging an architectural peer review consultant. And as I understand it, the applicant was objecting to that. Under the regs, 760 CMR 56.05 paren 5 paren little a, it says that the board may employ outside consultants for design review of buildings and site. And it Chapter 40B, Section 20 says that requirements and regulations shall be considered consistent with local needs if they're reasonable in view of the regional need for low and moderate income housing. It goes on to say that that one consideration is to promote better site and building design in relation to the surroundings. And that's where it says if such requirements and regulations are applied as equally as possible to both subsidized and unsubsidized housing. So to me, that clearly suggests that this is an appropriate topic to look at. I'm sure the applicant's arguing that this isn't required for typical developments, but it doesn't say applied equally. It says applied as equally as possible. And normal developments don't have the kind of issues we're dealing with because normal developments wouldn't be on lots that are unbuildable. But I just look at this. This is my view. I don't know what the board's view will be, but the proposed units are different from homes built on conforming lots with conforming setbacks. As I understand what's been said before, to deal with the high water table, you'll be bringing in a lot of fill to raise the level of the lots so that the septic meets the requirements that it be so much elevation above the water table. So the houses are going to be closer to the street and to each other. They're going to be elevated. And so these are not going to be exactly or comparable to typical houses built on developable lots in this neighborhood. So to me, I look at all of this and I see issues that are appropriate for architectural peer review. And I think the board has the authority to engage a consultant for such purposes. But I wanted to give you a final chance to address the issue before we put it to the board for a vote.
Mr. Chair, all I'll say is that no other single-family home, someone could build a single-family home on stilts. It's going to have to comply with, height requirements or get a waiver. We're not seeking waivers from height. So no other single-family home in Dover would be required to undergo architectural peer review, much less at the expense of the applicant. And I would also note that the quote is extremely high. And I would also note that, as I cited in my letter to the board of September 20th, the regulations specifically don't even require stamped architectural plans for a project of this size. And the architectural plans are preliminary. So what I heard earlier was that the lots are unbuildable because of wetlands. And I don't see a nexus between wetlands regulations and architectural peer review is attenuated at best. And that this would be, in my mind, a very clear disparate treatment of a 40B project from any other for single-family home development in the town.
Okay. So what I'm going to do is I'm going to ask the members of the board for their thoughts on everything that we've discussed so far. First of all, let's talk about the 2001 Dover case and what the implications of that are for this case. Anyone on the board want to comment or have questions? Anybody?
I was on the board when that decision was made, by the way. So I'm glad it still holds today.
Nadir or Mike or Nancy, any questions or comments?
Just to, maybe this is for Lynn, just given that she shared sort of the conversation she's had with sort of mass housing, just, in the course of the conversations around sort of the scattered plot, kind of nature of this project, was it sort of specifically discussed that the lots were sort of unbuildable for sort of the size and the wetlands concerns, or was that really kind of not yet addressed with mass housing and more the focus was on the fact that they were 4 lots in, kind of the same neighborhood?
Actually, the first question that they asked me is, why are you doing a 40B? And we said, because they comply with state wetlands bylaws, but not local wetlands bylaws. So yes, that discussion took place. And I will add that we also, gave them the tabular zoning analysis so that they were able to see with regard to the zoning bylaw how the lots complied or did not comply with the underlying zoning. So that specific conversation did take place, believe it or not.
And then the other question I had was, you mentioned sort of in those conversations, do you have a sense of how they reached out to the town of Dover? Because it seems like in the letter, it sort of specifically reflects that no comments were made. And I'm just curious as to sort of who they reached out to, kind of what that process looked like.
Yeah, in fact, I actually called your interim planner, and I actually reached out to your building inspector, and I reached out to your town manager. So I actually made the overtures to let people know that it was coming, to have conversations in advance that it was coming, and to let them know when there was going to be a site visit. And I sent a complete notebook to the town manager's office and gave them a heads up that that was coming in. In addition, a mass housing also basically did the same thing. They sent a letter to the, to the highest elected official my apologies to, which would have been the chair of the select board. So my notebook went to the chair of the select board. The state wrote to the chair of the select board, to the interim planner. And when we had our site walk, there was, 2 people from the town that attended, the site walk. I had thought one of them was a woman from the planning board. I can go back and look at my notes to see who attended, the site walk. So we made every effort we could. At that particular point in time, we are dealing with the highest elected official during the 30-day comment process. It is not something that typically the zoning board gets involved with at that particular point in time, because they don't want to, you know, there's an issue kind of prejudging, if you will.
So next, just a question for Jonathan. Jonathan, when sort of discussing the nature of the sort of scope of the ZBA's kind of review, I think you focused heavily on sort of the bullet point that's in the PEL that sort of highlighted the state and federal environmental laws. But I understood Alan to also have been referencing sort of that last sentence of the paragraph that sort of finishes at the top of the page that really frames up that we are to review, you know, kind of the project to ensure compliance with applicable state and local standards and regulations. And I'd just like to hear your thoughts on sort of how do you reconcile those two pieces?
Yeah, so the way I reconcile that is that the process is always that local bylaw requirements are on the table. We have to ask for waivers, and the board has to make a determination about whether a specific local need or local concern, which is reflected in a local bylaw or regulation, outweighs the regional need for affordable housing. That is a determination that's made based upon the evidence adduced during the public hearing. So that wouldn't be a determination that, well, these lots are unbuildable and it's a scattered site, therefore we can deny. It would be our peer reviewer is telling us that this project cannot be approved or conditioned in a way that would avoid the road flooding or the neighbor's basements flooding or some other very specific determination that there's going to be a negative impact as a result of this project, even though it's going to has to comply with state and federal requirements that outweighs the regional need for affordable housing. And that does happen from time to time, and in very rare instances. One of which is a case that Mr. Murphy's office handled and frequently cites. The HAC actually upheld, or actually, no, the HAC didn't, but a court upheld a denial or determined that a denial would have been appropriate based upon such negative impacts. But in 90+% of the cases, when a local board makes that fact-specific determination that a project was appropriately denied because it didn't comply with a local zoning provision, the HAC overturns that because the regional need for affordable housing is so extreme that absent real evidence of negative impacts that are really significant, the HAC will overturn a denial. Now, I want to be really clear. That doesn't mean the board can't consider those issues. And maybe at the end of the day, the board determines that those issues do outweigh the regional need for affordable housing. But that's different from making a threshold determination that this is a scattered site project on lots that would not be buildable under zoning. Therefore, we're going to deny.
Yeah. You know, one of the things that the Farm Street case, really focuses on, right, is the the notion of sort of expectations and the need for sort of consistency with zoning laws. And I'm curious to hear your thoughts, because I think we've heard very clearly from, kind of the community members around sort of the expectation about those lots and kind of whether that they would not be buildable or built upon. And so I'm curious to hear your thoughts on sort of how to reconcile kind of what the court seemed, or what the sort of HAC seemed to focus on as sort of a foundation for their decision, separate from sort of who got to review and who got to consider, right? Because I understand the sort of revisitation by the sort of funding agency, but now recognizing kind of that still remains kind of a truth here. I'm curious to hear your thoughts.
So this is not relevant to my legal analysis.
Sure.
I think that decision was wrongly decided then, even under the old NEF program, for a couple of reasons. Number one, the statement that there was no benefit because, on one of the scattered sites, because that particular scattered site didn't contain affordable housing, ignores the fact that absent that scattered site with that market rate unit, there would not be an affordable unit on the other site. And the same holds true here. So, that for what it's worth, I think that was an erroneous determination. And I think that the reference to expectations is, I honestly didn't understand that, because I can tell you that I've seen 40, 50, 100 unit projects on parcels that might not have been developable at all, or might have been developable for 2 or 3 or 4 units under conventional subdivision. And those projects violate expectations of neighbors much more than this project, which would have housing unit, single family homes on lots of more than an acre. So the issue of, violating the expectations of neighbors, first of all, I very, very much doubt that when a neighbor bought their house, they went and did a detailed determination as to whether the lot next door was developable. I think that's a fallacy. If people were being honest, I think everyone would acknowledge that they don't do those sorts of analyses before they buy a house. They may wish that the abutting lot remain vacant, but that's different from suggesting that they bought their house after doing a detailed zoning and wetland bylaw analysis to determine whether or not the lot next door of over an acre was buildable. But putting that aside, I'd say, we could come back with 4 unit townhouse projects on each of these lots, one of which would be affordable. And that would clearly be a much more significant violation of the expectations of neighbors. And maybe we have to build up super high to fit those units, but we could fit them. And I don't think that policy, that rationale in that 20-plus-year-old case really made much sense even at the time, and certainly not now, where the housing crisis is the primary focus of most state agencies under this administration and even under the last administration, in a way that it wasn't previously. So I don't think even under the old NEF program, that decision would have come out the way it did if it were decided today. But that's speculation. So I want to be clear.
Yeah, right. You mentioned sort of the regional need for housing. I mean, just, given sort of the scale of this project and that there are 3 sort of market rate houses and 1 that's going to be affordable, you've referenced kind of the sort of, sort of in not exactly kind terms, the current sort of percentage in Dover, but I guess what's the impact of this additional house to that percentage, right? It's minuscule at best.
I'd
Recognizing
say
that it will be impactful to that family, but just
That's right.
Focus to
I
the
mean, I
extent that
guess
your
it's,
focus has been on just sort of the percentage and the need to improve it. We're really talking about the addition of one that's going to be less than what 0.01% change.
yeah, it's not going to move the needle significantly on the percentage, but it's going to move the needle in an
Sure.
extremely meaningful way for one family. And I guess it's a matter of perspective. No more than the 3 market rate units are going to significantly impact the denominator of that equation.
Okay, any other comments or questions from board members?
No.
Laverne.
Well, it's not really the scattered nature of the sites that's bothersome. It's the fact that they'll have to be raised up. My next door neighbors, it built their house in the wetland, and it's now 12 feet taller than it was before. It's going to impact the runoff that goes into the river. There's 2 rivers down there. You've got Trout Brook, you've got the Charles River. There's many things that are wrong with this site, other than the fact that it's scattered. I don't even know where to begin, but that's my comment about this thing. It's unbuildable lots. You've got septic systems, you've got water. I don't know what these problems that people are going to have with so much mold and runoffs and everything that's going to happen in that site. It's just not a good spot. Thank you.
Lynn, can I ask you, have you and your people determined how much fill is going to be brought in and how much these houses will be raised above current ground level?
You know, that is a better question. I don't know if Scott is on the line. I think that we are still wrestling with that right now, given the new survey work that we've done. I think we can potentially, should the hearings continue, look at those issues and try and see if we can provide some answers. They're
I can offer a little
definitely
bit. I can
fair
offer a little
game,
bit more insight, Lynn, if you'd like me to. I mean,
please.
we know this project can comply with the Massachusetts Wetland Protection Act, which is both. There was a lot of talk about wetlands and sensitivity. You know, these projects are not being proposed inside of wetlands, and to the extent that there's portions of floodplain on the lots, it will meet all the rules and regulations for working on lots that are on or near floodplains. So under the Mass Wetland Protection Act, the foundations and such are all have to be sited above the groundwater table. So these houses are going to meet what is traditionally recognized as Mass Building Code standards and Wetland Protection Act standards in most communities in the Commonwealth. So yeah, I think once we get into it, and the board here and the Conservation Commission will find that all the rules and regulations of the Commonwealth are satisfied here. Now keep in mind, we are going to be filing a notice of intent submittal with the Dover Conservation Commission. And so this project will require orders of conditions to demonstrate that. So that full review will be occurring at some point in this process here shortly.
So is the short answer, you haven't determined yet how high the houses are going to be above current ground level?
The houses are gonna be, right, the design issues we're gonna have to be sorted out. That'll be part of the review. We'll present that all to you, but we're not proposing to do anything in violation of Mass Building Code.
No, I understand, but my specific question, you don't have an answer to yet, is that right?
Sure.
We don't. We will hopefully have some answers
fine.
when we have new plans next week. But also to address Laverne's concern. In addition, we're going to be going through Title V Board of Health. So this project is going to have its tires kicked at least 3 times between the ZBA, the Concom, and the Board of Health.
Okay. So we're not ready to quite conclude things yet, but in terms of how much time you need to finish what you're doing and get it to us and give us time to review it before we meet again. What are we looking at in terms of scheduling?
I'm just gonna, so Scott, let's see. What day is Thanksgiving this year? Is it the 23rd? Is it early?
23rd. It's the
It is the
23rd.
23rd.
So it sounds like meeting the week of the 13th is probably too soon.
Oh, next week? Oh, in 2 weeks?
13th, week after next. We're almost the end of this week, so that's
Yeah,
a week.
I think,
Hmm.
I think the 30th is probably the week of the 27th is probably a better suggestion.
I don't want
'cause
to do the week of the 20th because of the Thanksgiving holiday.
27th.
And the 27th, I don't want to do because people may be returning still from being away for Thanksgiving.
Oh, I was looking at the 30th, which is like the Thursday night.
28, 29, 30th is probably the earliest.
Yeah, 28, 29, 30. Yeah, we just, we're going to be giving some changes, and we just want to make sure that everyone has enough time to review it. We don't think it's fair to make you rush and do the review in a week.
Well, no, whatever you submit has to be reviewed by the board and its consultants. That'll take a little time. So
Yeah,
you do all those dates work for you, 28, 29, and 30?
Scott and Jonathan. Wait a minute, let me just.
Yeah,
make
I
sure.
think that'll be fine.
I
They all work for me.
have, I have something on the 28th, hang on. I'm okay on the 29th or 30th.
But not the 28th?
Yeah, I'm sorry about that.
That's okay. So members of the Board of Appeals, do the 29th or the 30th or both work for each of you?
Yes,
Yes,
Yeah,
Yes.
both work.
Mike?
Mike,
Not
you're
hearing you.
muted.
He gave a thumbs up.
Okay,
Huh.
and then if everyone can do that, I would have a preference on the 29th, just because I realized there was something.
Well,
on the 30th.
I'll have to check, well, I guess we need to pick a date, because I don't know for sure, about our other folks, but, I'm sorry, who said, did you say you had a preference for one date or the other? Lynn?
29th?
Okay. So let's plan on the 29th. So, first thing I want to do is ask the board whether you have any comments about engaging an architectural peer review consultant.
I have no comment.
Anyone particularly for or against it? Anyone think we shouldn't do it or think we should?
Yes, this is Mike. Yes, we should. We owe it to the people that live in the neighborhood that have to look at these houses and walk past them, for the rest of their lives. Yes.
So I generally take the view that these are pretty distinguishable scenarios, right? That these are the kinds of lots that we don't have a lot of comparable things to look to sort of, examine our past practice. I do think that there's sort of this unique quality to the fact that they are sort of otherwise unbuildable and sort of, the way that they are being proposed to be combined. I think it gives us reason to kind of have a deeper look. So I would be sort of interested in.
Okay.
Nancy?
I'm indifferent. I don't really think it's necessary. Quite frankly, I think I've seen the architectural plans. I think they look quite nice. Yeah, so I'm, if I had to, my vote would be, I don't think it's necessary.
Okay. Well, I think from my previous comments, you may be able to tell, I think it would be appropriate. So I'll entertain a motion to retain a architectural peer review consultant, Cliff Bomer, and his firm, at the applicant's expense. This requires a 2/3 vote. I'm sorry, a majority vote, which is 2 out of 3.
Could I
Um,
say something before you take the vote?
Yeah.
If this is the way you want to go, then I would respectfully request that you get a quote from another peer reviewer, because the cost is exponential to this project. We certainly have other names that we can give you for architectural peer reviewers that aren't going to cost the amount of money that's being quoted.
Well, Mr. Ballmer specifically told me that he thinks it won't be anywhere near that much, but he was giving a range quote as a kind of a worst case scenario. Also, we don't have any obligation to solicit other quotes. And, our work with Cliff on the previous project, his work was perfectly appropriate and reasonable and not excessive. So I'm not worried about that. So I will entertain a motion to retain Cliff Bomer and his firm as an architectural peer review consultant.
So moved.
We have a second?
I second that.
Okay, and so this requires a 2 out of 3 of the full members, which is Laverne, Nadir, and me. All in favor? Laverne's a yes, Nadir's a yes, I'm a yes, so it passes unanimously. Okay, so I think at this point we need to have a motion to continue the hearing to be resumed on November 29th at 7 p.m. on Zoom.
Could I again ask that no peer review with Cliff starts until we get our new set of plans in, if what your concerns are, at what height are the buildings, please?
Oh, sure, no, but if you're going to be submitting something to us in the next week or so, then we'll wait to get that before either of our consultants do anything further.
And how are you going to handle this decision? Again, because we don't want to spend good money after bad with regard to this issue of scattered site. When is that going to be decided?
So what I want to do is I want to have a chance to digest what everyone has said tonight, see if our Judy Barrett or our town council have any further input on the issue, and then we'll deal with that when we resume on the 29th. Now, I don't want to I don't want to put us through the full hearing process if that doesn't seem appropriate, but I also don't want to, not knowing what the board's going to do on that issue, I don't want to have the board deny the permit on that ground alone, and then lose the opportunity because of an immediate appeal to have any further review of any remaining issues. And if part of it will depend on what your submission is. If it looks like there are other significant issues that we either think are objectionable or require conditions, then we'd want to discuss those and decide what our position is on those, so that if there is anything to be appealed, whether a denial or approval with conditions the applicant doesn't consider appropriate, then we can have an appeal that addresses all of the issues and not have to come back for further proceedings, or not lose our right to address other issues because there's been a early appeal of the one issue that is not in our favor. So it's a difficult question. You can argue that it's better to go one way or the other. It isn't apparent to me that there's a clear choice, but we want to look at it further, and then on the 29th we can see where we are.
So I think I misunderstood where you were going with this. And if you want to have a meeting in the next week or two to decide this matter, we would be happy to show up for a meeting for that. But I think it's highly unfair to ask the applicant to continue spending money on engineering and then spend money on peer reviews if that is where you're headed. So do you have a sense of how soon you feel you can get to an answer on that issue?
So, Lynn, it sounds like you're almost done with what you're going to be submitting to us. We would like to, I would like to see that. I don't, I, I don't think that peer review, what we're talking about here, the magnitude of expense from the peer reviewers looking at whatever you're going to submit to us before our next meeting um, is going to be anywhere comparable to the costs incurred if there's a denial of the application and followed by an appeal that goes through at least the HAC and possibly beyond that. So I think to me it makes sense. I mean, you can do what you want. You can submit something or not before our next meeting, but um, I think to me, it makes sense to submit what you're putting together and we'll have for us in the next week or so. We can at least take a preliminary look at it for our next meeting. And then we'll see where we are. I don't, whatever you give to us, the next meeting is not going to be the final session of the hearing process, unless we end up with a denial based on this preliminary issue. So I think it makes sense to move forward with you giving us the further information you're putting together. We can evaluate that before our next hearing session, and it'll give us a much better sense of where we are and how to proceed.
Well, I think if we're going to give you the plans and we're going to have a hearing, we are going to have the expectation that your peer reviewers will have issued their comments for the next hearing. That is, where we're hoping to land at the next hearing, that we are starting to review substantive matters on this. And if that is what your intent is, then we will go ahead and submit the plans and hopefully have our consultants interacting with your peer reviewers so that we can have a robust meeting on the 30th.
Well, then, we have time constraints in terms of finishing this hearing. And I don't know what you folks are assuming is going to happen, but it's not a foregone conclusion in my mind that we're going to do any kind of denial based on this issue raised by the 2001 Dover case. We may do it, but we may not. And I'm far from reaching any decision or any opinion as to what's the appropriate way to go. So we've got a couple of choices. One is to just freeze everything until we decide that issue. I think it's probably in your interest to move forward with giving us your additional information so we can evaluate it and make a more informed decision on where we are. So with that, I will entertain a motion to continue the hearing to be resumed on November 29th at 7 p.m. via Zoom.
So moved.
I have a second.
Second.
All in favor?
Aye.
Okay, so we'll look forward to your submissions, Lynn, and we will see everybody on the 29th.
Thank you, Mr. Chairman.
Thank you. Good night, everybody.
Good night. Thanks, Alan.
You're welcome.